Today we're going to talk about a favorite topic, at least among attorneys, and that's the issue of attorney's fees. We have with us Casey. Casey's going to go through a case. She'll break it down for us, and it'll be useful for anybody that goes to court that's either asking for attorney's fees or is being asked to pay for attorney's fees. Stand by. Hey, Casey, how are you?
Hi, Don. How are you?
Good. I can't wait to start talking about this appellate court decision, not only because the decision itself is interesting, but because I haven't done one with you in a long time, and you always give a good analysis on these cases. So what's the name of the case we're talking about today?
So this is the Hearn case, Hearn, and this case is out of Marin County, California.
Okay.
And it is an attorney fee case.
That's why it's so interesting. When we say attorney fee case, we want to emphasize attorney, and you'll explain why as you're going through this case, I'm sure. So tell us about it.
Okay, so big picture, we have an attorney fee case. We have husband and wife. They're going through a divorce. They have been in and out of court. The court has made various orders regarding division of a 401k, regarding attorney fees, lots and lots of things going on.
And the decision starts with the parties are involved in a hotly contested dissolution.
Hotly contested, and might I add, I think one of the most important facts of this case is that husband is an attorney, and he is a self-represented attorney.
We don't know what area of law he practiced, do we?
We don't know, but we know that he was the feeling I get from the case is this was like fun for him. He was on a playground, and this was his playground. He was doing everything that overzealous, litigious attorneys may do, but he was doing it in his own case.
For himself.
To the detriment of his wife, who was paying counsel to defend against all of his litigation.
And I didn't, again, see what area of law, but my imagination went towards family law, but I don't know if that's true or not. But these people had been to the appellate court a few times.
They had been to the appellate court a few times, and coincidentally, ironically, whatever you call it, husband is appealing an order to give wife $15,000 in fees. So the underlying case in Hearn is wife asking for $45,000 in fees so that she can fight husband on his appeals. And then another interesting tidbit is that when husband filed these appeals, he had not complied with the underlying court orders. He had not paid half of the 401k. He had not paid wife the $15,000. So all of that leads up to him filing his appeals, and then wife filing a motion for $45,000 in attorney fees. And then the kind of legal issues that this case is addressing is overall attorney fees, number one, and number two, there's a discussion about something we learned in law school called unclean hands, which we'll talk about in the disentitlement doctrine, and also when you're entitled to an evidentiary hearing, when a court can deny it. So those are the types of things that this case addresses.
Okay. So in wife's declaration in support of her request for the court to order husband to pay $45,000 of attorney's fees, that again was related to the appeals, she puts some data regarding her own finances in her declaration, right? Right.
So, wife has to show under Family Code 2030, which she didn't cite, but the court inferred that's what she was relying on. She was relying on her need. Really, the law is respective need and ability.
Can we stop right there? Mm-hmm. I found that interesting. I don't know if it was novel or not, but I know that when I've been in family court before, the failure to cite what authority you're going under, the courts will say, well, you haven't really cited me any authority, so I'm not going to rule. Here, the appellate court inferred.
Right. The court inferred, and also it did it, I think, on both sides. It made inferences on husband's side on certain things, and it made inferences on wife.
In the interest of justice.
In the interest of justice, wife was represented, but, she argued her need, and the record supports that she was justifying her need for attorney fees because of her needs. The things she cited were that this is during COVID, this is 2020, she indicated that she was not working, that her unemployment was exhausted, and that she was caring for 2 young children. She does have income. She has $7,000 a month in trust income, but she made arguments indicating that it was a distribution that it was somewhat diminishing
Yeah.
over time, and also the trustor can decide if the payments were going to be reduced. But overall, she's saying, I have to pay for an attorney, and I don't work, and I'm caring for the children. And husband, in response, he focused on his inability to pay, and he responded by saying, I'm an attorney, but I'm not working.
Okay, so under 2030, there's a basic analysis, right? One is going to be, one side, the person asking, I have the need. I can't pay for my own attorney's fees. I need some help, Your Honor. And he's got the ability. So the wife's made these two arguments. I have need. He has ability. He's countering, as you just said, by saying, I'm wrong. I don't have the ability.
Right. He's saying, I don't have the ability because I don't work either. I don't work, and yes, I'm an attorney, and yes, I previously made six figures, but I'm currently not making that money. And he's also indicated the evidence is a little bit shaky, and it looks like the court didn't like that husband provided inconsistent information. He says on the one hand that he's involuntarily unemployed, meaning he's fired. On the other hand, there was evidence presented, I think, by husband himself. When he applied for unemployment benefits, he cited his need to care for young children as the reason that he couldn't work.
So there's some conflicting information. In his responsive declaration to her motion, he also attacks her statement that she doesn't have the ability to pay. And he says what?
Well, he says that she has significant trust income. So she's a trust fund person, and he's saying that
she has over $1 million of financial assets.
Right. That she has more assets than he has, and that she has the trust income.
Okay, so they're making the basic arguments. I don't know if we need to really pause too long on the arguments, because it doesn't really go to the crux of the decision. But people should know that this is the thing that you would argue. When you're in court, is you'd be attacking need and ability, and it depends on which side you're on, of course.
Yeah, and I think another part of the discussion in the facts section, and I think also goes into the overall analysis, is, family law is not a science in many parts. There's the law, but family law is a court of law and a court of equity. So equitable arguments, fairness arguments, totality of the circumstances arguments are always fair game. So when we look at need and ability, we're balancing financial need, financial ability, but we're also looking, I think, at burdens, overall burdens. If we have an attorney who's representing himself and not paying, he's not paying his own attorney, and then we have a wife who is having to pay hundreds of thousands of dollars in appellate defense and also in family law, I think the judge is taking that into consideration. And this is where it hurts husband, because husband is arguing, I can't even pay for my own attorney. And here is where he gets dinged, because what we all need to remember as practitioners and litigants need to remember is the court's looking at whether someone has the ability to pay for both their attorney fees and the other person's attorney fees. So that husband can't afford his own lawyer is actually used against him, because he doesn't have the burden to pay a lawyer, and therefore he has money left over to pay for her lawyer. So I just think that's a really interesting,
good point. Yeah.
really interesting way. And in fact, in practice, is something that I recently dealt with in a case where the judge emphasized to me, I have to see if he can afford to pay for both, not just, your clients, both. Can he pay for both? And that, I think, cuts into the, it can cut both ways, but the person that's asking for fees has to consider whether the payor has, what are their debts, what does their income look like, and what are their expenses. You have to be prepared to look at not just your client and ask for what you want. You have to be prepared to show where the sources that the other person can pay from.
You know what, you're bringing up a really important point, and quite frankly, it escaped me when I read this decision, but it depends on at what point in the hearing, too, because you're saying that the court has to look at well, I need to consider his ability to pay for his own attorney and hers. But if you're at the end of the case, let's say that a person voluntarily or even, claims that they couldn't afford an attorney, but we're at the very end and the only issue is attorney's fees, then the court's probably not going to put so much emphasis on whether he could pay for it, because it's a done deal, you know what I mean? So they're really looking at whether he could pay for hers, right?
That's true.
Yeah.
At the end of the case, that's the way it would be. I think during the pendency of the case, there's more of that urgency of making sure that the parties are on equal footing and have equal access to community property to pay for their attorneys, and all of those other considerations that support temporary attorney fee orders. The other, I think, tidbit that needs to be highlighted is wife makes a comment or a very practical comment. She says that husband is making his best efforts to wear her down, and basically what is something that we attorneys refer to as, when someone is papering you to death, or they are, trying to bleed you dry. When one person in the litigation has more power, more access to records, more money, when there's an imbalance of power, they are trying to sometimes use litigation tactics or the expense of the litigation to force the weaker side to capitulate and receive, a mediocre offer of settlement. So there's no law to back this. I hope there's probably a case out there, but the practical point is a good one, and one as a practitioner that is something that you need to emphasize. If you're on the side where your client is just getting overrun with motions and court appearances, and that pretty soon they're not going to be able to have an attorney, and your client's thinking about settling just because they can't litigate. I mean, that's a pretty sad situation, to settle on less than what you think is right for your children, or your property or your retirement, because you can't afford to litigate. So I think that's important to tell the court there's an imbalance of power here. We need to be on more equal footing, because even negotiating power is less when you have that scenario. So I think it's a practical argument, but a really strong one that was made.
Sure. And we do see that a lot with pro pers that are attorneys. A lot of times the attorneys don't know what they're doing, but they sure know how to make a mess out of things when they're representing themselves, and drive up the fees purposely. And that's what she was claiming that he was doing. Right.
She claims he was driving up the fees, and then a husband's argument of, well, I'm not working. We call it divorceitis, where someone all of a sudden can't work and they don't have money and their business isn't worth anything. Well, he wasn't able to hide behind that. There was a discussion in the case of Marriage of Sullivan, and it talks about an attorney fee award. We don't have to just look at your income. We can look at your earning capacity. And you're an attorney, and you recently made X amount of money, and you indicated that you were looking for jobs and networking, and you were applying. So we can assume that very soon you are going to make that money again. So the court has this discussion about, the ability to rely on Sullivan and look at someone's earning capacity instead of just their income.
Yeah, because in this case, the trial court had actually taken into consideration husband's earning capacity, even though he was unemployed, and he claims that, it was in the best interest of the children during COVID that he not kind of work, or he couldn't work as much. And wife was still arguing, hey, this guy's a skilled attorney. He could get out there and get a job. And the trial court found in her favor in that regard, and actually basically said, you do have the earning capacity to pay fees. Now, we see that argument a lot when it comes to paying support. I don't see it a lot when it comes to you have the earning capacity to pay fees. Right. And that's why I thought this would be fun for you and I to talk about, because it's another thing for us to consider when we're going in and asking for that. Because usually the judge is going to say, well, I need some proof that there's liquid assets. I need proof that there's, a history of earnings. Well, what happens if that person is purposely not working, and hiding behind their assets or whatever they're doing and stuff? I mean, earning capacity can be used apparently.
It can, and interestingly, in this case, husband, there was, I don't know if it was husband, there was a comment made about liquidity, and there is equity. There are assets. The court has to look at your assets, but there's often in the real world, and in this case, a comment about, oh well, it's not liquid, so it's stuck in the house, and so we're not really going to focus on that. So the court did make that comment in this case, but then turned around and looked at husband's earning capacity. Overall, I think that husband was kind of, I don't know if the word punishment is correct, but husband he was behaving badly. He provided inconsistent evidence about why he wasn't working. It was very suspicious that he's all of a sudden not working during the pendency of this case. He's filing multiple appeals, and then, he didn't even comply with the underlying order, which we can talk about that. There was a whole discussion about the disentitlement doctrine. So overall, I think that he was over litigating. So I think he was behaving badly, and the court wasn't going to let him get away with it.
Let me pause on this again. For practical application, the earning capacity argument, I think, can be used based on this decision, even if a person isn't perceived to be acting badly. I think, what about that carpenter who's not working right now because of the strike? So they can't go to the movie sets and put together sets, but the person is capable of working out in the public and finding jobs and everything, but is choosing not to do so. Or any other type of a job where somebody, for industry reasons, is temporarily out of a job. We could, I think, argue that this person can still work.
I agree with you, Don. I think the earning capacity is kind of something that is a general takeaway from this case, the discussion of Sullivan. Commentary about husband's behavior is really just commentary and really kind of a practical look at this particular case. It's not necessarily law that can be transferred to other cases, but it's just a comment and something that I think would be a takeaway for me, just in the real world, and advising clients how to present evidence and how to behave when they're in litigation.
So you were talking about that. There's some discussion about the disentitlement doctrine, and what I found interesting is his wife had claimed that he had no right to appeal, or he shouldn't be allowed to appeal based upon that doctrine. Could you explain that?
Yeah. So the case has a good discussion of the doctrine, and ultimately the court didn't rely on this doctrine to dismiss the appeal. Nevertheless, the discussion is here, and it's a nice reminder. Disentitlement doctrine is something that we study in law school. It's what we also call unclean hands. It's basically, if you're asking for court relief, but you yourself haven't complied with valid court orders, the court shouldn't give you any relief because you're coming into court with unclean hands. So there are a lot of great quotes in the decision about the doctrine, but essentially it says that the court has inherent power to dismiss an appeal by a party that refuses to comply with lower court orders. And it says a party to an action cannot, with right or reason, ask the aid and assistance of a court in hearing his demands while he stands in an attitude of contempt to legal orders and processes of the courts of this state.
So what I thought was unique about that, because earlier in the year we covered a disentitlement doctrine case at the trial court level, and the question was whether or not the trial court had properly, decided that issue. But here it's up on the Court of Appeal. And I thought it was interesting that basically, even though it wasn't the ruling because the court decided to hear the case, it didn't invoke the disentitlement doctrine, but it could have. And I thought that was interesting based upon the conduct that occurred at the lower court. The court, thought, paused, and said, well, this is something that could possibly happen, but we're going to choose not to do that. We're going to let him argue at the appellate court level. So people should be warned, right? I mean, if you're violating court orders and you're not behaving, and even if you have a valid appeal on something, you may be denied that based on equity.
You may be denied, and I think the takeaway from the discussion is the discussion of what you need to show for a case to rise to the level of the disentitlement doctrine, and that is willful obstruction or failure to comply with trial court orders. So it has to be Willful obstruction. So if someone, like husband in this case, sprinkles in an excuse for why they didn't comply, like, I didn't have the ability to pay, I couldn't, I didn't have the cash flow to do it, or, by the way, Your Honor, I didn't pay it, but she owes me money. So if you look at what she owes me, then I don't owe her anything. And then the third excuse he came up with was, which is what I thought saved him, is, no, Your Honor, you ordered that if I can't pay this on time, that I'm going to pay interest.
Yeah.
So
Right.
I'm going to pay interest, and I'm not denying that. And then wife herself, she didn't contest that, in fact, she owed him money. So I think that, if the court's going to use unclean hands with him, then it's going to have to use unclean hands with her, and it's a big mess. So bottom line is, there has to be a willful obstruction, and husband in this case got away with it by sprinkling in some excuses for why he didn't comply with the order. The court didn't have enough, and the court certainly wasn't going to have, a published decision, because that is going to become law, and we're all going to run with the disentitlement doctrine. So
Yeah.
the court didn't have enough to do it in this case.
Now, there was one other issue that I think was actually, when I read this a second time, I thought, okay, I missed the main issue because I was focusing on the earning capacity, and I thought that's what I'm going to be talking to people about at the end of the year. This is a great case because of the attorney's fees, but really I think that the main holding was the husband, the attorney, he wanted a continuance of the trial. And he wanted to put on evidence because he claimed that he found evidence that she was lying, and he needed more time to put things together. And what did the trial court say about that?
Well, it's interesting. So the discussion, to lay out the framework, the discussion is about, husband's complaining because he claims he was denied an evidentiary hearing, number one. And then he claims, number two, that the court made a finding of good cause to deny his request for an evidentiary hearing. He claims that it wasn't good enough cause. So he basically complains about not having an evidentiary hearing. So the discussion in the decision is about, what you need to do to essentially set up a case for an appeal. And what husband did wasn't enough. So husband basically would file papers. He'd file a first, second, and third supplemental. And he was kind of over litigating the case. So when he would receive a response from the other side, he kept getting he got continuances, and ultimately he asked for a continuance so that he can do more discovery and submit more documents and submit more evidence. So what the court said was, well, no, you didn't ask for the magic words, which is my takeaway from this case. The magic words are, you wanted to testify, or you wanted to cross-examine. You wanted to cross-examine your wife, or you wanted to cross-examine a third party. He never asked to cross-examine. He never asked to testify. He asked for continuances, and he asked to submit more documentation. And even if the court gave him an evidentiary hearing, he didn't ask for the magic words, which is, I want to cross-examine my wife. He didn't ask for that.
So when people want what's called a 217 hearing, they should be very explicit, and they should probably put it in writing, right, at the beginning, and not be vague about what you're asking for.
Yeah. See, the mistake is even if the court gave him a 217 hearing, you have to ask to cross-examine the other party. So if you tell the court, I want an opportunity to present more evidence, the court could say, fine, I'll let you submit a pleading. You don't have to have an evidentiary hearing for it. But if you ask to specifically to cross-examine someone and then you're denied, that's where I think the case that was cited here, Marriage of Swain, that's where this case differentiated from Marriage of Swain, because in Marriage of Swain, the litigant specifically said, I want the right to cross-examine, and it was denied, and then that was overturned on appeal. But in this case, husband just said, I want more time to file more papers, or I want more time to do more discovery. So that was the issue of the evidentiary hearing. And then there was also the issue of good cause. So if the judge denies the evidentiary hearing, the court has to make a finding of good cause to refuse the live testimony. And then there are various factors that the court can consider. But the decision indicates the judge doesn't have to go through each and every factor. The judge only has to recite the factors that it relied on for the good cause. So, the court's going to look at whether there are material facts in controversy, whether live testimony is necessary for the court to assess the credibility of the parties, and the right of the parties to question anyone submitting reports or other information to the court. So the court's looking at all of those things. In this case, the court just didn't think it was necessary. As you said, it was hotly contested. There were multiple continuances already granted. There was a plethora of pleadings, lots of supplemental declarations. There had been ample opportunity, and the court recited the good cause. So the Court of Appeal just didn't think that there was anything to complain about. Yeah. And it sustained the decision to not allow the 217 hearing.
So I wrote down the quote from the court that the Court of Appeal quoted of the trial court. It said, quote, "This matter has been so exhaustively briefed," and also, quote, "I do not believe an evidentiary hearing would provide any information that could and should have been included in the parties' written submissions." And I'm wondering if those are kind of like magic words for a trial court, and when I looked at this case, I don't disagree with the decision of the trial court. And of course, I don't want to disagree with the Court of Appeal, but I wonder how strong the Elkins Commission attempts to provide justice and evidentiary hearings in court. Is this a camel's nose under the tent type of thing? Because now we have an appellate court decision that the trial courts are going to be saying, well, Mr. Schweitzer, I think that this matter has been so exhaustively briefed, and I do not believe that an evidentiary hearing would provide, and I'm seeing that courts are, they're pushing back a little bit on us asking for evidentiary hearings. Frequently, I just did one, and the trial court said, what's your time estimate, Mr. Schweitzer? And I said 4 hours for my side, and I don't know how much time for the other side. And after he heard that, he said, well, I think this thing's going to go no more than 2 hours. And knowing that this judge wasn't going to allow it, he was going to put the timer on, I had to make a suggestion that we just cross-examine each other's clients, introducing the declarations. So I'm seeing courts do that more often, and I'm not opposed to it so long as I get some time to actually put on evidence and things like that. But I was a little bit concerned that this might be one of those cases that the courts are going to be using to deny us 217 hearings. I guess we'll have to wait and see, right?
Right. And, as I was reading this and rereading Family Code 217 and California Rule of Court 5.113, it's almost framed in a way of, well, it does say, the court shall receive live testimony. So it's framed in a very strong way that way. But in the real world, we kind of do it in the inverse. We kind of analyze a case and decide, okay, this one I think we're going to file a request for a 217 hearing. We don't automatically do it for all cases. And I think from the judge's perspective, if we do ask for it, like you said, they are scrutinizing why we need it. So although the code is written in a kind of affirmative, strong, you're going to get this live hearing, it's not really like that in the real world.
Yeah, it's a pushback of the volume of cases that are out there in LA County. It's hard for courts to give meaningful evidentiary hearings on every single case. So it's a judge, I suppose, has to decide on a case-by-case basis, and it's probably a lot harder than what it seems like. One of the other things that I thought worth noting is that there are some appellate court decisions, and you're familiar with them, that say that an attorney representing him or herself cannot ask for attorney's fees, right? But in this case, he wasn't asking for attorney's fees, but the trial court said he's really valuable. I mean, look at he's providing himself with all these services. Look how skilled he was. So there was an emphasis as to the benefit of his attorney skills were to basically save him money. And it's kind of interesting that an attorney who wants to represent him or herself gets it from both ends in a way.
Yeah, that's exactly right. It's like, oh wow, look how you're saving everyone money, and therefore there's more money left over to give to the other side, because she can't do that. Yeah. So it's as many times as often happens in family law, one particular argument will cut you both ways. So it's our job to just have that discussion with the client and say it's going to cut us this way over here and this way over here, then we all know that going in, and making our decisions is whether we're going to make those arguments or not.
Yeah. And
So,
how many appellate court decisions have we read through the past several years where attorneys have been up on appeal and they look like fools, and stuff. So I end with the quote that what Abe Lincoln once said is that he, and now it's she, who represents him or herself has a fool for a client. And I'm going to add, especially attorneys. So, thank you very much, Casey. This was very good. I think it was informative for a lot of people, whether you're a lawyer, a self-represented lawyer, or just a person who needs some help and everything. Understanding attorney's fees will go a long way. Thank you very much.
thank you, Don.
And thank you, and we'll see you next time at Exhibit A.